Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Now, I will acknowledge we're going to get a little bit out of our lane here. We're not going to talk about gun laws. We're not going to talk about gun rights, but we are going to talk about the United States Supreme Court, in particular, one justice of the United States Supreme Court. Why is that? Well, because this person, like the other 8, will ultimately be responsible in deciding what the Second Amendment means to all of you. And while there were some things early on that I could have chalked up to growing pains or just, trying to get her feet wet or whatever you want to call it, it continues at an alarming pace. And I think there is now a moment of reflection that we have to have. So today we're going to have that moment of reflection. And I'm going to ask all of you the following. Serious question. Is she in over her head? Okay, now, America, we're going to need to talk about a Supreme Court justice who yesterday had a terrible, terrible day. But the problem is this isn't the first instance. It's not the second instance. It's not the third or the fourth. This is a pattern of conduct. And when it goes beyond an isolated incident into a reoccurring pattern of conduct, we need to have this discussion. We're going to talk about Justice Ketanji Brown Jackson, and we're also going to be talking about the case of Robinson versus Calais. This is a twice over now constitutional challenge to Section 2 of the Voting Rights Act. It was heard once before by the United States Supreme Court during their 2024 term. It is back before the United States Supreme Court, focusing exclusively on Section 2. The dispute comes from the state of Louisiana intentionally gerrymandering their legislative districts to ensure that there were 2 predominantly African American districts. So essentially, and they admitted to this, and they were doing this intentionally, they were gerrymandering these districts based upon the ethnic and racial breakdowns of those groups. Now, during oral arguments, and this captured everybody's attention, especially in the exosphere yesterday, Justice Brown Jackson stated the following.
A kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact.
Okay, now, that was reported by multiple outlets. I'm trying to think who didn't actually report that. So it would appear that Justice Brown Jackson is equating a person's skin color to a disability. And you sit there and you go, wow, that is pretty crazy. Yeah, it is really crazy. Never in a million years did I think I'd be doing a video about a Supreme Court justice making those types of statements. But then you go back and you take a look like, well, we've already had to do a couple of other videos about this judge. She's only been on the bench now for a couple years, and she's making a name for herself, but for all the wrong reasons. And this is kind of what I want to go through with you, America, is I want to go back in our timeline here, and I want you to understand that this is a pattern of conduct. Take, for example, the following. She's a new justice. So typically when you see new judges come to any panel of judges for the first year or two, they kind of just stay quiet. They're a little bit like when you join a board. If you're the newest member of the board, you kind of sit there for the first several meetings and get a feel for things. Or like when you pledge a fraternity, you probably shouldn't walk down into the chapter room and tell the fraternity president how to run the operation. Obviously, Justice Brown Jackson does not cut from that mold. She immediately engaged quite actively in all cases, all questioning. And that leads to one of the other big concerns that I've seen in her, which is the massive amount of solo dissents. Now, dissenting from the majority's opinion is not uncommon. We see this frequently. However, typically, with the United States Supreme Court, we will see the 3 liberal justices or a combination of a couple conservative justices and liberal justices actually file dissents collectively. It is rare that you will see a single solo dissent. Not rare when it comes to Justice Brown Jackson, because of the 20 dissents and or concurring opinions that she has shared in, 17 of them have actually been solo dissents or concurring, which tells us that even if she's getting to the same conclusion that the majority got to, or she is disagreeing with where the majority has got to, the legal reasoning by which she is justifying her position is not in sync with any of her colleagues whatsoever. Her judicial reasoning has come under considerable attack, with a July 25 column in the Telegraph describing her dissents as intellectually indefensible balderdash. And a similar comment and opinion piece was shared also on The Hill. Now, here's the thing. While those may be conservative publications, let us remember that there are also 2 other liberal justices on the bench, Justice Kagan and Justice Sotomayor. And you can go back and you can take a look at the library here and take a look at a lot of other content creators and then take a look at those publications, or any publication for that matter. While certainly people may be critical of the results that they reach, you never see that type of criticism leveled against Justice Kagan or Justice Sotomayor's legal analysis. So is that potentially yet another issue with Justice Brown Jackson? But then we get to perhaps our biggest concern, and something that's actually caught the attention of even casual Supreme Court observers, and that is her very divisive rhetoric. See, it's one thing to write a dissent and explain why you disagree with the legal reasoning of the majority. It's another thing to basically call them out, or in what's happened in many instances here, is Justice Brown Jackson has come this close to calling the majority idiots, and in many ways actually accused them of trying to undermine the United States Constitution. Take, for example, the case of Trump v. Casa. This was the case that limited district courts' abilities to issue nationwide injunctions. Justice Brown Jackson was very upset at the majority opinion, so much that she wrote, again, her own solo dissent, which caught the attention of the majority author, Amy Coney Barrett, who actually used Justice Brown Jackson's name multiple times in the majority opinion, ripping apart her very divisive and angry rhetoric that was littered throughout her solo dissenting opinion. She was quoted there as saying, "As I understand the concern in this clash over the respective powers of 2 coordinate branches of government, the majority sees a power grab, but not by a presumably lawless executive choosing to act in a manner that flouts the plain text of the Constitution. Instead, to the majority, the power-hungry actors are, wait for it, the district courts." That's the type of language that she uses in her dissents. And she's even labeled rulings by the majority of the United States Supreme Court as law-free zones. Not making it up. This also comes from her dissent in Casa v. Trump. Thus, the law-free zone that results from this court's near elimination of universal injunctions is not an unfamiliar archetype. Also, eerily echoing history's horrors is the fact that today's prerogative zone is unlikely to impact the public in a randomly distributed manner. So when we take a look at Justice Brown Jackson's performance to date, when we take a look at the quality of the questions that come from the bench, and when we consider these statements right here,
manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact,
we do have to really ask ourselves, hey, is she in over her head? I ask all of you, what do you all think? Let us know in the comment sections below. What do you think about Justice Brown Jackson so far? All right, now listen, in the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should now get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Okay, let's remember, like always, all the research we did for today's video was done where? That's right, at Ground News. Why is that? Well, I like to get treated like an adult, and I bet you do too. And when you have a platform that's going to scour over 50,000 independent news sources and give you a biased distribution breakdown, let you know how the headlines are being manipulated, oh my gosh, it actually allows you to make up your own mind. Check out the blind spot. This will show you stories that are being disproportionately reported by one side of the political spectrum or the other. And right now, you can get every feature that Ground News has to offer through a Vantage Plan at 40% off. And all you got to do is go to ground.news/Washington or scan this QR code right here. Listen, if you're finally ready to break free from media manipulation, visit my friends today at ground.news/Washington.